Hello. Can everybody hear me? We're getting a feedback thing here. We're going to work on just a second. I think you need to mute. Right. All right. I think we got the feedback. Mute the TV. We got the feedback issue resolved here. Welcome, everyone. I hope everybody managed to make it out in the snow. My name's John Landy. I'm an attorney here at the Dickinson Law Firm. I want to thank all of you for joining us for our annual Ag Lending webinar. Okay, all right. Sorry about that, folks. We accidentally hung up the phone line there. Getting a slow start here on a snowy January day. Like I said, we appreciate everyone joining us for our annual Ag Lending webinar. We can tell by the attendance and the concerns that you identified in your registration that this is an issue that everybody's paying a lot of attention to this year. Before we jump into the presentations, I'll just note a couple of headlines that have come out in recent weeks and days, starting with last November, a report from the Minneapolis Federal Reserve titled Chapter 12 Bankruptcies on the Rise in the 9th District, which covers Minnesota, Wisconsin, and the Dakotas. Then a couple of days ago, the New York Times came out with a headline, Pessimism Looms Over Prospect of a Sweeping China Trade Deal, with a quote from Senator Chuck Grassley that there's been no progress on structural changes by China, which is what the U.S. has been asking for in its China trade agreement. And then finally, just yesterday, the Senate is set to vote on two bills that could end the shutdown, but both are expected to fail, according to NPR. So we're dealing with some uncertain times right now, absolutely. And so the purpose of today is going to be to kind of cover some of the practical pointers that we think ag lenders should be thinking about with their loan documentation, and as well as some tips for things to maybe talk to your operators about. But with that, I'm going to turn things over to start with the newest member of our ag lending team here at the Dickinson firm. Emily Staudiker joins us from private practice in Grundy Center. And so she comes to us with a general practice, but is well versed in these ag law issues. So we'll turn things over to Emily and get started. And I should remind everyone, too, that you can ask questions in the comment box and submit those. The format of the presentation will be Emily will kind of go through her presentation, and then the rest of us here, the Ag Lending team, will kind of do updates of our presentations that we did last year that you can also find on our Ag Lending website if you go to the Dickinson Law Firm website. And then after that, we'll have kind of a Q&A session based on some comments that were submitted. But by all means, during the webinar, if you have questions that come up, please submit them, and we'll try to respond to them in real time. So with that, take it away, Emily.
Okay, thanks, John. First, I'm going to start by going over an economic outlook for the ag economy in 2019. And I'll start off with trade. Trade is expected to be down for 2019 by about $1.9 billion. That's largely due to the decrease in soybeans and cotton that will be exported. Soybean export volumes are down because of declining Chinese purchases from the United States as a result of the trade tensions. And the export value is also down due to a record U.S. crop. Grain and feed exports are forecasted to be up $700 million to a total of about $33.8 billion, driven by higher corn and wheat volumes. And livestock, dairy, and poultry exports are projected to be down about $200 million to a total of $30.1 billion. And the declines in poultry and dairy products are offsetting expected increases in beef and pork products. As John touched on, there's a bunch of important variables that will contribute to the trade numbers in 2019. First and foremost being China trade negotiations. As a result of the trade war, the U.S. is projected to move from China is projected to move from the U.S.'s second largest trading partner to the fifth in 2019. 99% of all U.S. agricultural products exported to China are subject to tariffs. And the biggest concern is that the U.S. will lose out their corn and soybean market to other countries, Brazil being one of them. Looking at the price gap between Brazilian corn and U.S. corn, at its height, it was a difference of $2.42 a bushel. So that is a major concern going forward. As John kind of touched on, recent negotiations seem to have halted further escalation for the time being, but there seems to be little progress on the removal of trade barriers that were put up in 2018. Another variable being the U.S.-Mexico-Canada trade agreement. The ratification timeline is unknown within Congress. The president has threatened to leave the NAFTA agreement if Congress refuses to ratify the USMCA. This trade agreement increases access for dairy products into Canada and keeps agricultural tariffs between the U.S. and Mexico at zero. Moving on to the rest of the world, Japan, there's talks that Japan may enter a free trade agreement with the United States. This would help pork because Japan is the #1 export market for pork. So that could increase pork exports if that gets done this year. Additionally, EU negotiations are ongoing. They have mentioned that agriculture will be included. With the state of Brexit right now, all of that is a bit up in the air, but that is moving forward hopefully as well. As far as the livestock forecast, there is expected to be record production for beef, pork, and poultry. Prices are expected to remain similar to 2018, but are contingent on trade, especially with China and Mexico. And we can expect volatility in the markets responding to news regarding those trade agreements. Crop forecast, corn is expected to be slightly higher. Soybeans are expected to continue to drop a little bit due to the trade issues and, as I briefly touched on, the possibility of South America taking over the market. I should also note that farmland values for 2018 were down slightly from 2017. Considering the downward pressure from both declining farm income and rising interest rates, the farmland values in Iowa and across the U.S. are actually remarkably stable. In 2019, we expect a modest decline in overall land prices, but a trend towards stabilization, at least. So to touch on the overall outlook, it's not so good as one of the responses from the Magic 8 Ball predicts. The market facilitation program payments are not likely to be made for the 2019 crop year, even if the trade war continues. One of the questions that remains is whether yields can continue to be above the trend line. At trend line yields, the projection of average farm income is a loss of $60,000. For the past 4 years, I believe, or at least 2, the production has actually been above the trend line, but it's hard to say whether we can expect that to continue into 2019. If yields continue to beat the trend line as they did the last 2 years, income projection would be a loss of $3,000. Additionally, inputs are expected to increase, such as fertilizer, labor costs, machinery, buildings, and higher interest rates will have an effect as well. At the beginning of the presentation, John mentioned a report from the Fed that Chapter 12 bankruptcies are on the rise. I've got a couple of diagrams here for you that give you a better idea of what we're looking at. Current numbers are not unprecedented. However, current price levels and the trajectory of current trends suggest that this trend has not yet seen a peak. Here we're looking at the relationship between ag prices and Chapter 12 bankruptcies. Not surprisingly, bankruptcy numbers inversely follow the rise and fall of commodity prices. You can see in 2010, it reached its peak and prices started rising, and logically, bankruptcies started pivoting downward at that time as well. This last diagram from the report is the level of bad ag loans at banks in the bottom 25% from this specific district. And these banks have a comparatively poor asset quality to begin with, and the path of their asset quality often acts as a canary in the financial coal mine. So we can see that these banks are seeing quite the uptick in Chapter 12 bankruptcies. It's worth noting as well that Wisconsin has been hit the hardest due to the dairy industry. Wisconsin's dairy farms tend to be quite a bit smaller than the dairy industry in California, for instance. So they are more susceptible to downturns in the economy. Next, moving on to the Ag Economy Barometer. This is a nationwide measure of the health of the U.S. agriculture economy that the Purdue puts out on a monthly basis. And numbers from December of 2017 and December of 2018 are almost exactly the same, just a 1-point difference. The takeaways from that survey is that the December 2018 Index of Current Conditions, which gives producers perceptions of the current ag economy, was substantially below 2017. However, the Index of Future Expectations was actually higher in 2018 than it was in 2017. So farmers do expect the economy to continue to improve. As expected, trade disputes continue to be a major concern for producers. The percentage of producers expecting U.S. ag exports to decline over the next 5 years greatly increased from 10% in November to 26% in December. And producers overwhelmingly expect contraction to take place in the nation's dairy herd. Beef is expected to contract as well, and hogs are expected to expand. Overall, the variables to look out for in 2019 as to the progress of the economy would be the trade agreements, what the Fed does with interest rates, and if they increase those, any policy changes that might occur, and as always, farm income as they relate to yields and commodity prices. Okay, next I will move on to warning signs of ag loans in trouble. We can break these warning signs into 4 categories, which are financial, management, operations, and banking. Financial warning signs would be when you're looking at the actual financial documents, such as the cash flow statements and balance sheets. Management would be the personnel and the people actually managing the operations, and signs that come from that aspect. Operations are the day-to-day production aspects of the farming operation, and then the banking signs, which would be changes in banking behavior. Some financial signs that a loan may be in trouble would be if a borrower is providing you untimely financial information, or if they're simply refusing to provide financial information. That would be a sign that they are perhaps trying to hide something. Deterioration in cash position or a zero or negative working capital is also a sign. If you're seeing zero working capital, or producers who are taking out operating loans on a consistent basis, that could definitely be a sign as well that they're just not covering their cash expenses. If there's an increase in non-productive fixed assets or living expenses, this may go more toward the behavioral aspects of people, but if you have borrowers who are purchasing large assets that don't seem necessary, it may be an indication that they're trying to hide their financial position to friends, family, neighbors. If borrowers have wide disparities between projected and actual results, that's an indication that they are being unrealistic and are not perhaps being forthcoming with the lender as well. Another sign would be an unusual use of 179 depreciation. So if you see from past tax returns that they had used, just standard depreciation or double declining balance for a certain amount of machinery, and then all of a sudden are using all 179, that could be a sign as well. And then an increase in accounts payable, especially if you're seeing an increase in credit card debt. That's another financial sign that a loan could be in trouble. Next, moving on to management signs, you would be looking at more the personal habits of the borrower, such as change in behavior, what their lifestyle is, if they're having personal or marital problems, if they are venturing into new businesses without perhaps having a lot of foresight into it, if their desire and insistence to take business gambles and undue risk increases, that could be a sign. and unrealistic plans for the future, and hiding finances from lenders and family members. Operation signs that indicate a loan or an operation may be in trouble would be poor maintenance of equipment or capital assets, or deferred replacement of machinery. If you're seeing a difference in trend as far as their asset replacement schedule, that's a good indication that there's some cash flow issues there as well. If record-keeping practices decline, that could indicate that, again, it's that psychological aspect. Nobody wants to be made aware that things are going poorly, so they perhaps don't keep records as they should or as they had in the past. Additionally, a sale of assets outside the ordinary course of business is a good sign, and if their crop yields are consistently below county averages, that's another sign as well. Banking signs would include the inability to get timely financial information, changes in deposit patterns. So if you notice uneven deposits that don't match up with past years, that could be a sign as well. If they're transferring operating accounts to other banks, that could be a sign that they're trying to hide what's going on in their operation to some extent. Like I briefly mentioned earlier, loans for working capital. If you notice other lenders in the picture, that kind of goes back to the aspect of trying to hide what's going on, and if borrowing continues after a seasonal need has passed. Another thing I have noticed that could be a possible sign is if a farmer upgrades a combine, for instance, and the amount of the loan is more than what the old combine was worth, that could be an indication as well. So what can a lender recommend to an operation that may have trouble paying a loan back? Well, they can increase cash flow, decrease living expenses or off-farm expenses. They need to focus on break-evens and marketing, so focusing on parts of the operation that are making money and keep doing that, and discovering what parts of the operations are not making money and perhaps not doing that anymore, getting rid of that part of the business. The next one is part with money-losing land, which we know is going to be the last result for most producers, but sometimes it's the reality of the situation. They should examine the return of investment on capital expenditures. Make sure that new combine is worth the return that you're going to get from it, or if you have a specialized piece of equipment, perhaps rent, share, or sell it if it is not producing a return that makes it worth sitting in the machine shed. Additionally, if farmers can do it themselves instead of hiring for manure spreading, chemical application, power washing, things of that nature. And finally, they could contact the Extension Office. Iowa State has a program. I believe it is free to farmers, but they will come in and look over all of the financial documents and give recommendations as to how a producer can increase their cash flow. I think the main takeaway is that cost control is huge. I saw some numbers where in 2016, the top 20% of producers in Minnesota, their cost per raising a bushel of corn was $3.06. The bottom percent was $4.44 per bushel. So that's a huge difference in cost per bushel of corn. And so I think the main takeaway is to look at cost control. That concludes my portion, and I will turn it back over to John.
Thank you, Emily. And Emily, you have some experience specifically with farming, is that right?
Yes. My uncle and grandfather are hog farmers in northeast Iowa, and I live on an acreage myself and raise a few show pigs every year. So.
Well, thank you, Emily, and I think there's a lot of good information that you've given everyone to think about. So we're going to kind of segue now to discuss or some points that some others of us have made in prior years ag lending webinars. And I'll go ahead and get things started with kind of an update / refresher about organic farming, because I think if you've got operator who's experienced years of tough going and we don't really see any relief coming in commodity prices, one of the very attractive options that at least initially might appear available to operators is to switch some portion or all of their operation to organic farming. And I bring this up because I've seen this tried in several cases where the operator is kind of at the end of it, and the lender's saying, no, we're not gonna let you go any farther. And the operator comes in and says, well, look, if I switch to organic, I can maybe double or increase by 150% the price that I get for my commodities. I'm going to do that. And what's important, I think, for all of us to keep in mind is that past performance is usually an indicator of future performance. I say that not only because I think that's what experience teaches us, but that's what the bankruptcy courts have said. And so as you're evaluating any of your operators' proposals for the future, it's just like Emily said, you need to look at what their history and track record has been, because the conversion to organic is very difficult. First of all, you start with an immediate cash flow problem, because you've got to have fields that are free of prohibited substances for a period of 3 years before you can get that organic certification. The organic certification process itself costs money. You have to have an organic certifier come out, review the operation, implement a plan for maintaining the organic status of the field or of the operation. You have to ensure that your pest and weed management practices are adequate. And in talking to producers and folks who successfully made this transition, it takes several years to really fine-tune those processes and practices to really get yourself to a point where you're producing a sustainable crop using organic methods. And then finally, it's always important to keep in mind the yields can go down when you've got a fully organic operation. And so while there's still probably a net benefit in terms of the overall commodity price, it's not going to just take the prior yield and double the price. There's going to be there's going to be a more nuanced change than that. So as you're dealing with operators who are coming in, whether it's organic farming or some other plan like Emily suggested, maybe to diversify their crops, you need to look at the entire picture, not just look at what could happen. You have to evaluate what the operator's past performance is, and probably, although in this circumstance this isn't necessarily true, but probably if an operator is kind of close to the line to begin with, then an organic switch may not be the answer to their troubles. So I would expect to continue to see this as an option that's raised, especially if producers go into bankruptcy, because in bankruptcy, you're going to have to show something new and how things are going to be different. And that's a really easy way for most operators to try to demonstrate how things are going to be different.
Okay, the next topic that we're going to discuss briefly over the lunch hour here is what happens when things go very poorly and you're forced to consider foreclosing on whatever loan we have that's become distressed. There are 4 key points to remember that we have on the slide for the next part of the presentation. The first one really is we've given this presentation in past years, and we've gone into a fair amount of detail about the process itself. I don't see the point of belaboring it in this context. I would suffice it to say that ag foreclosures are very code-driven, and by that I mean the Iowa Code as promulgated by the legislature. Get attorneys involved very early. Most ag lenders are fairly familiar with the initial notice provisions and the attempts to mediate. There still is nothing wrong with getting attorneys in at that early point, even if it's just monitoring what the loan officer is doing. Belt and suspenders is often the prudent course with most of the successful lenders that I work with, so that would be my recommendation. I would also point out probably most of the loans that we're talking about in this context are fairly significant dollar amounts, but I would also point out that we can have varying dollar ranges with the loans that we're talking about, and a bank should never feel leery about contacting a lawyer for assistance on a smaller dollar loan. The fact of the matter is that because the way the loans are written, because you're always going to be awarded your attorney's fees, and Iowa judges are very comfortable with those types of awards, no loan is too small to seek our assistance, such that we would recommend getting counsel involved as early as possible, regardless of the dollar amount. I would also point out, and we're going to talk a little bit more, the latter parts of the presentation today are going to talk about negotiations with the borrower, getting this information that we're emphasizing you need to know as a prudent lender, and having conversations. That can still continue once you file a foreclosure. Frankly, I've never seen an ag foreclosure go all the way through to a sheriff's sale. It's probably more likely in the most recent foreclosures that I've handled, there is continued negotiation with the borrower even after the suit has started. Sometimes it's just the catalyst that needs to be in place in order to get the borrower truly motivated. And then my last point of observation, and perhaps it's exactly inconsistent with everything else we're telling you. We're telling you to try to know all this information and to get information from the borrower and to get information from the economy and to get information from the environment, to get information within your institution. And the truth of the matter is you're never going to have perfect understanding of why the borrower is doing what the borrower is doing. The most recent foreclosure that I had in this arena in ag land lending, the borrower ended up bringing in some additional funds and basically curing the deficiency and reinstating the loan. At the same time, the borrower actually went through a foreclosure with another creditor. And we truly didn't understand the distinction between why they were willing to give us some more funds and why they were willing to go the full boat with the other creditor. And I don't know that we really necessarily care, but I guess I just would point out to the institutions that we counsel, you're never going to have perfect information. It is important to have the best information you can to make the best decision that you can, but don't be too bothered by the fact that there's always, particularly when you get to my point in the equation, there's always a bit of a question mark as to why the debtor is doing what he or she is doing. Just learn to live with that and get the best information you can for your decision making. Try to run your own race and focus on your own actions rather than guessing what the borrower may or may not do.
Okay, I just want to probably briefly touch on what we've talked about in past seminars too, but ultimately when you have a stressed credit, prior to handing that file off to Molly for foreclosure, there are some things that you need to identify or at least explore, which might truly determine exactly how you attack those problems. So first and foremost, analyzing the file. I imagine you guys do regular file reviews. We've been requested recently to come in and do kind of an outsider's look at some stressed files, because ultimately you're looking at signatory issues, notary issues, legal description, potential issues, collateral value, inconsistencies between the note and mortgage, all those items can be truly troublesome in a foreclosure matter. So if you have a stressed credit, but you have a cooperative borrower, which a lot of times you do, for at least for a while, you can get those items addressed and kind of packaged and covered up prior to ultimately, if it ends up in the foreclosure track, having to fight that battle at that point. So it can kind of clean things up. And again, we've been handling a number of kind of outside, I'll call them outside analyses or analysis of reviews. I think it gives a separate set of eyes. A lot of times if you look at your own problems, you don't see them. Again, we do that on a pretty efficient basis and method here, so feel free to reach out in that respect. Loan and mortgage modifications, that's usually kind of the first request when you are dealing with a stressed credit. Trying to get more favorable repayment terms. There are some considerations that you truly need to know about and look at, not just sign the form amendments and CITs. You know, you need to be aware of potential priority issues depending on what your documents say. Enforceability issues again. So feel free again to reach out once you reach that point where there are some potential modifications to be made, and we can at least give a blessing or give some comments as to what the proposal may be. Forbearance agreements, again, this is an effective tool to use when you have a cooperative borrower and ultimately you're trying to find a path forward. A lot of times it can be an indication that the future of the credit is in jeopardy, but it at least gives everybody an opportunity to see if there is a path forward, at least temporarily. There are a number of provisions that you want to make sure that you include, and again, it's buttoning up any previous warts in the loan file. You're going to want to button up essentially the validity of the loan documents, so you acknowledge the validity of the loan documents or have the borrower acknowledge the validity of the loan documents. You don't want to fight about what the actual indebtedness amount is, so you have them acknowledge that amount right away, acknowledge a default. Again, these are all issues that you want the borrower to attest to or agree to right now, so you don't have to fight that battle when Molly has the file, and it's much more expensive and burdensome and tough to overcome. And ultimately, I think another key component in those forbearance agreements is you want to release. You know, you're ultimately giving them something there. And so whether it's a lender liability claim or potential lender liability claim, you want a release of any and all claims from the borrower to, again, make that file as clean as possible at that point in time. So that's kind of my 30,000-foot flyover description there of what I talked about. And again, we point you to our previous seminars that go a little bit more detail there. So appreciate it.
Brad Cruz is our firm's one of our firm's bankruptcy experts. Brad couldn't make it today, so I'll jump back in with just a couple of thoughts to go over Chapter 12 bankruptcy. I begin with a thought that was shared by one of the attorneys in our office who's also a farmer, and that is that a farmer is going to keep farming until you take the keys away. And that is definitely true in every bankruptcy that I've ever dealt with. And Chapter 12 bankruptcy is just one more mechanism for that farmer to keep on farming. You've gone through your loan review with Ben. You can't make it work with the operator, so you've commenced foreclosure proceedings with Molly. At that point, the only way that the farmer may think that they can continue to operate is to declare Chapter 12 bankruptcy. And the reason they'll do that is that under Chapter 12 bankruptcy, the farmer or the operator remains in control and in possession of the operation and gets to continue to operate. There's a presumption built into Chapter 12 of the Bankruptcy Code that the farmer is the best one to continue to manage the operation. You might question that because you've got an individual that has put themselves in this position where they're needing bankruptcy protection in order to continue to operate. You may rightly question whether or not they really are the best one to continue to be in charge of that operation. So when an operator declares Chapter 12 bankruptcy, as with all bankruptcy, it's hands off the operator. You've got to go to bankruptcy court from now on to get permission to do some of the things that you may need to do in order to protect your collateral. A couple of the things you may want to contemplate fairly early on in the bankruptcy process is whether you want to go to court and immediately begin the process to try to get the bankruptcy dismissed. And in a lot of these troubled loan environments, I think that's a question that lenders should be asking themselves pretty early on, because in a bankruptcy, in order to reorganize, the operator is going to have to either right-size their operation. They may try to, strip down debt, but more likely they're going to have to demonstrate to the court what it is that they're going to do now that's different than what they were doing that got them to this point in the bankruptcy. And this kind of goes back to my organic farming piece. The bankruptcy court's going to be asking the same question that you all are asking, and that is, what is different now? And in a lot of cases, there really isn't going to be anything that's all that different. And in my experience, operators can use the Chapter 12 process, even though they're not supposed to sort of string out what is ultimately going to be the day of reckoning, which is when their operation is going to have to be liquidated. There's a number of mechanisms that they can use in that process. They can ultimately, the operator is supposed to propose a plan for reorganization that is supposed to provide treatment for various classes of creditors. Frequently, those plans get litigated, and so you find yourself waiting, the full 90 days for the operator to propose the plan. Then you litigate the plan. Then the operator has to go back and propose a new plan, and all of a sudden, it's been 6 or 8 months in bankruptcy, and you don't know where the time has gone. And so, one of the things that you may want to do early on in the case is filing a motion to dismiss the bankruptcy to alert the court to the fact that this is where you think this is headed. You don't see any feasible route for this operator to reorganize, and what you're really looking for is kind of a managed liquidation of the operation. The operator will probably disagree with that, but this is where all of your due diligence up to this point becomes really important, because this is where you demonstrate to the court, the track record of the operator, where they have failed time and again to follow through on the commitments that they made to you in their forbearance agreement. This is where you demonstrate the reasons that you put them into foreclosure in the beginning to begin with. And this is also where it's vitally important that your documentation be buttoned up, because the bankruptcy court is going to have very little sympathy for a lender that doesn't have a security agreement that adequately describes the security or collateral that you're trying to take possession of, and those sorts of things. So this is where you really are under a microscope. The bankruptcy code is set up to put the lender under a microscope at this point. And so that's why it really pays to have done the due diligence ahead of time, because ultimately you could be rewarded with a fairly expeditious dismissal of the bankruptcy case. So Brad obviously has a lot more detail about this in last year's presentation, but by all means, please contact us if you do get notice that a lender or a borrower has filed for Chapter 12 bankruptcy.
All right. My topic, the last seminar, dealt with the underlying loan documents. Most of my information here is going to be kind of the no-duh quality, but just because it's basic information doesn't mean it's not important. In fact, it's probably more important than a lot of the other information, because it's essential to even the forming of the contract. My first point here is don't overlook those basics. You would be surprised, and you're probably saying, thanks, Jeff, we need to know that we need to get the borrowers right. We need to know that we need to get the legal description for the property right. But you would be very surprised at the number of problems that arise and the number of disputes that revolve around the wrong names being in the loan documents, the wrong, whether it's you have the wrong entity or you have an entity versus the individuals, and who those proper parties are. The loan documents aren't signed, or they aren't signed by a spouse. The notarization is all messed up. Either the notarization wasn't dated or it wasn't notarized, and you can't record documents unless they've been notarized. Those are essential things that you need to make sure double, triple check these items, because they're so essential to them. And I don't think anyone has mentioned today in this presentation here my second point, but make sure you review your loan documents. I'm joking, of course. This is like the fourth time that we've talked about it, but that's because it's very important. Some of the essential terms that you want to make sure that you have in here that give you the best position to enforce your loans include ensuring that you have homestead, if it's applicable, that you have the statutory homestead waiver language, that you have information, or that you have spouses that are added to the document, that if it's a purchase money loan, you have the recitation that it is a purchase money loan, so that you get that elevated priority over pre-existing judgments. If there is personal property involved, you want to make sure that your documents include, either separately or within some of the other documents, security agreement language that adequately provides you protection on those personal property items. And then the third point kind of dovetails with the second point, but that's making sure that your loan documents include items that either protect your collateral, that give you rights and security interests, and the right to inspect and the right to appoint a receiver. That kind of goes into the security agreement. Make sure that you have a UCC-1 financing statement prepared correctly. It's essential that you get the specific, if there's an entity involved, that you have the specific identical entity filled out. If that's in any way defective, you're going to lose your security rights. And you need to get that financing statement filed with the Secretary of State's office. If you don't have that, again, your security interest is going to go away. Having the inspection rights to inspect collateral gives you the opportunity, once it gets to Ben and Ben's doing the file review, or to Molly or to Brad, that you have the right to go in and make sure that your collateral is protected, that your collateral is there. Similarly, the right to appoint a receiver gives you, as the bank, the right to go in and take over control of those operations when you need to, because the borrower is not taking those or not maintaining the collateral in the correct way. And just as Ben talked about with having file reviews, we also can provide you with review of your document packages ahead of time, so that you know, not after you get into a potential default situation or not after you get into a problem situation, but every loan that you enter into is going to have these protections built into those documents, and we're happy to do that. And I'm saying that even though that means that Ben and Molly's jobs are going to be a little bit easier and a little bit less hours involved, because the stuff's done from the beginning. So I think that covers my topic.
Thank you, Jeff. So now we're going to just spend a couple of minutes responding to some questions that we got from attendees both before the presentation, and then, as I said at the beginning, if you have any questions based on anything that anybody has said up to this point, then by all means type it into the comment box, and we'll try to respond to it in real time. One of the things that we've talked about up to this point is, signs of distress. Emily kind of covered signs of distress in an operation. And, Molly, suppose you have a borrower that has checked every box that Emily set out for us, and we've decided we need to pull the plug for a variety of reasons. What, as a practical matter, is the first step that happens if you've decided that you need to ultimately foreclose on an operation?
That's an interesting question, and it gets back to, I don't recall which one of us pointed out, but what I think is most interesting about some of these conversation points is the psychology involved in it. I think it was Ben talking about the objectivity of looking at the situation, and that you need someone to come in, because frankly, from my experience, loan officers don't want to pull the plug. And my first direction on this point would be, and John and I had talked about this a little bit leading into today's presentation, the lenders that act most prudently up front, and we're sort of presuming that we're getting into a period of increased activity, both for us and for you on this front. And it's our prediction that the lenders that take the steps to begin with, even though they don't want to, are probably going to fare the best. The handwriting's on the wall. You're in a position where you have a distressed borrower, and if you act prudently, with your gut in a conservative fashion with the help of counsel, you're probably going to fare better than those lenders that wait until there really is no source of recovery or no opportunity for recovery. This gets back to the specific steps are going to be, well, we're talking about secured loans for all of these types of arrangements, whether it's secured by personal property, which is basically just something that's movable, or whether it's secured by real property, the dirt. Or I guess we could also throw livestock into that. So we're going to have something tangible. And for any lender, we're going to say, you look at the loan documents, 99%, maybe more, maybe 99.5% are going to give you as a secured entity the right to come in and preserve that property in an adequate fashion to make sure that you're not harmed by the manner in which the borrower is handling that property. That's easy to say. It's not necessarily easy to do. That means for the personal property, and it sounds odd, but livestock is probably considered personal property because it's not real property. That means that you need to, as an ag lender, you need to have boots on the ground that are going to be ready to take physical possession or control of the livestock, of the grain, to make sure that at the right time of the year, the fields are being harvested, the grain is being dried, and et cetera, et cetera. Farm managers will probably become an ally in this with you, but in most instances, the law is going to protect you in retrieving and taking physical possession of that collateral as long as you do it in a fashion that you're not breaching the peace. And you're supposed to do it in a way that we're not upsetting anyone, and that's a bit of a reach because, of course, the borrower is not going to like these actions. With regard to real property, in 99% of the cases that I'm involved, I recommend that we at least consider a receiver. Jeff had talked about having your documentation give you the right to a receiver, and all the loans that we do are going to give you that protection. The relevant sections of the code give some additional protections to the borrower where a receiver is concerned. And it may not be very common that we actually see receivers in those instances, that typically the debtor stays in possession. But nevertheless, I think it's something that the lender needs to give some consideration to the idea of, do we want to, quote unquote, take physical possession of the ground? And that would usually be vis-a-vis a receiver. So that would be my recommendation, would be that we would do what we can to make sure that the collateral that secures our lending, whether it's personal property or real property, is well taken care of. That doesn't mean you're actually going to be bringing these things into the bank, but you're probably going to be finding somebody that can help preserve that asset for you. I do recognize that probably results in some level of an expenditure. You're probably going to have some farm manager involved, et cetera, and there's going to be some costs associated, which will in somewhat diminish the ultimate proceeds available. But let's not bend over a dollar to pick up a dime. Let's recognize in the long run, you want that collateral to be preserved. So collateral preservation is going to be your first thought, and that's with a lawyer's advice to make sure you're doing it in the right way, but that's not with a lawyer necessarily going out and taking physical possession. That's probably with someone who manages livestock or farms or grains or whatever it may be. So that would be my recommendation. It becomes very fact specific, and you really want to be very careful to make sure that you're not doing anything in actuality that harms the collateral, and also to make sure you're not doing anything in a legal fashion that upsets the balance inordinately under the code.
Thank you, Molly. We've had a question come in wanting to talk about exemptions. And so briefly, the exemption statute allows borrowers to protect certain assets from creditors. The most common or most often noted would be your homestead exemption that generally protects your homestead from creditors, although that can be mortgaged. And so that, if you've got a mortgage governing your house, or you pledged your house via mortgage, then that obviously wouldn't apply. The question was whether there are any different exemptions under Chapter 12 of the Bankruptcy Code. The Bankruptcy Code looks to state law for exemptions, and so whatever the exempt property is under state law is going to be what is exempt under bankruptcy. In most of these commercial ag operations, it's not really going to be an issue in all likelihood. You may not be able to take the last pickup from the operator, but other than that, almost any other collateral is going to be fair game for foreclosure. So that is an answer to that question. We'll check and see if we have any. We have another question here wanting to talk about timing on mediation, when to send, how long, etc. So that question, of course, relates to the requirement under the Iowa Code prior to commencement of foreclosure that you commence mediation or attempt to mediate with the farmer to try to work things out before actually resorting to legal process.
Well, and this is one of those ones that I literally, and full disclosure, I've been practicing coming up on 25 years, and not just in the foreclosure arena, but really for anything that's code-driven or rule-driven. I almost try not to remember the specifics. I just grab my rule book or my code, and that's exactly what I do here. So if someone calls me and says, here's the position I'm in, and the notice, and is it 30 days or 60 or 45, and is it from mailing or from the date of receipt, I don't have those code provisions memorized. Candidly, I'm always afraid they're going to change, and I'm always afraid that they're going to blend together, and then I'm going to forget whether the obligations under one section are blended with another. So I don't have the specifics with regard to that. If someone wants to follow up, my contact information is included in the material. So if there's obviously a specific question that's raised, I do see the question as to ag land secured by commercial purpose, is mediation needed? I see the question being phrased, I think I'm interpreting it correctly. If ag land is the security, yes, you are going to need to at least give the notice and to attempt a mediation. You don't necessarily need to have a mediation. I would say more common than not, in my experience, there is not even what I would call a real mediation. And by that I mean the borrower often does not participate or show up, and that's why it does become very important that you follow the correct statutory timing in terms of giving the notice and the time period allowed for the mediation and so forth. So I would say yes, it is required. If you have, the default is going to be when an ag attempts to mediate. Because again, we're going to be very mindful of the fact that we are an agricultural state. The legislature is going to have protections for the borrower, and you're always going to err on the side of caution in favor of the borrower or the operator in this instance. So you're going to try to mediate, even if there may be an intellectual or analytical argument that mediation isn't required. So what? Do it right, be conservative, and you're going to give it a shot. At least, again, in terms of the statutory notice times.
And if you go through with the attempt to get to go to mediation, if they fail to respond, or basically what happens is you submit the request for mediation to the mediation company. They then reach out to the borrower to try to have the mediation. If the borrower doesn't respond or indicates that they're not going to do it, the mediation company basically provides you with a release or waiver of that, which then you use to move forward. So it isn't something that the borrower is going to be able to hold you hostage by refusing to go to mediation or trying to delay the mediation. If they aren't playing ball, then you have avenues to move on.
And one thing I'd point out, I've seen this come up in a recent foreclosure. It's best to avoid using the old form that you've had in the bank for maybe since the last farm crisis, for your notice of default and your mediation request and those sorts of things, because the code, as Molly suggested, does change, usually in response to a downturn or a period of tightness in the ag market. And the trend has been for more protections to be added, not fewer. And what I experienced, or what I witnessed, this wasn't my foreclosure, is there being a serious dispute over whether or not a particular notice that was close but not exactly what the statute required satisfied the statutory requirement. And keep in mind, if you're at this point where you're involved in foreclosure, you're getting ready to go to foreclosure, the farmer is going to keep farming as long as they've got the keys to the operation, and they're going to use any argument that they possibly can make to try to keep control of that operation. And so a close enough notice of default, a close enough mediation notice and release may not be what you want to have if you're contemplating a litigated foreclosure, or even if you're not contemplating one. Just because being able to show the borrower, hey, look, we got it, we got everything lined up here. This is it. You don't want to have to necessarily fight those battles because it'll just drag everything else out,
or even worse, start over.
Right. Yeah. And that can add 12 months to any process, because already you've got a 12-month mandatory redemption period on ag land. And so if the bank's looking at credit bidding and taking control of that ag ground as ultimately how this is going to turn out, you're talking about 12 months before you're able to turn around and market that to a potential buyer after the sheriff's sale. So there's a lot of it's a long process from start to finish.
One more word of caution as it relates to those mediations, and again, we touched on it, but I'll clarify again. Typically, practically speaking, when we give that 45-day notice of default right to cure, that's when we send, or I send, the request for mediation. And again, that allows it to essentially coincide with that 45-day period. So once you hit that 45-day deadline, presumably you'll have your mortgage or your mediation release in hand and proceed down that path. With the mediation, I've seen where we have been involved, you got to be careful as far as if an agreement is reached at that mediation to extend additional time, et cetera. A lot of times it's a one paragraph, handwritten layman's, agreement of sorts. That
usually written by the mediator.
Written by the mediator that can cause more confusion than clarity a lot of times. And, I've had instances there where it's poorly drafted, poorly written. It extends the time period beyond, I think, what both parties truly intended just on the wording of the agreement itself. So, make sure who's ever handling that mediation is comfortable with what they're signing, what they're agreeing to, and certainly feel free to get us involved in that scenario too, because you're essentially drafting up a contract that can ultimately stymie or frustrate your efforts after that.
And you'll usually get pushed by the mediator to have something signed at that meeting. So to the extent that you can have an attorney there to either, and what I've done in the past is I've included in the mediation agreement that I usually will draft a more fleshed out a mediation agreement that the parties agree to execute within 5 business days or something like that, so that it isn't something that we're sitting down at 4:30 on a Friday trying to draft out real quick before everybody can go home for the weekend. It's something that you can actually put some time and thought into, and make sure that you have all of your protections and your boilerplate protective language in there as well.
We're just about out of time. There's just one last question that we'll address here, and that this one's kind of for Emily, as well as any others that think they have something to add. I think it would be fair to say that 100% of the registrants for this webinar were concerned about cash flow. And Emily, you kind of talked about some of the things to think about when you're identifying a troubled operator. How do you have a conversation with the operator about cash flow, and what are some of the things that operators probably need to be encouraged to do in this environment?
I think the first thing to do would be to sit down and have a conversation about the record keeping in the operation so that troubled areas can be identified. I know that farmers and producers are notorious for bad records, but that can certainly help a producer understand where the profitability is and where the losses are in the operation and adjust accordingly. There's many different ways an operation can increase cash flow. The easiest being to liquidate inventory of crops. I wouldn't necessarily recommend liquidating inventory of livestock, especially if those are breeding livestock and produce cash for the operation. But stored crops can be liquidated. You can defer capital asset purchases. There can be increase in non-farm earnings, so recommend that a family member get employment off the farm, and perhaps they can obtain health care with that, which is a major expense to a lot of farming operations. Another option would be if it's organized as a corporation or LLC, the entity could sell shares, perhaps to family members if they're more comfortable with that, and raise cash in that manner. That's just a few ways. Obviously, renegotiating leases due to decreasing farmland prices as well would be another recommendation.
In my experience, a lot of times, or the bankruptcies that I've been involved with, or the foreclosures I've seen, there's just been a reluctance by the operator to right-size the operation for too long, and there's a tension that we certainly understand. With the size of some of the equipment these days, it requires an operation of a certain size, but with the stickiness of cash rents, which haven't really seemed to decline in lockstep with the drop of commodity prices, it just isn't realistic for some of these operators to try to hold on to as much of the land that they've been holding on to. And that's a hard conversation to have. But this, the ones that are willing to hear that are probably the ones that you don't have any trouble with anyway. So, it's something that, you as an institution need to be ready to sit down with the operator and talk about. So.
And now is typically the time to start thinking about that and communicating that as, the operating lines come up for renewal or you discuss renewal at this point. These are benchmarks or conditions or requirements that you should put down on paper and make a part of any renewal that you make, saying, I want to see X, Y, Z. Otherwise, you're at risk of not having renewal next year. And, I think you truly need to not just assume both parties are on the same page. You need to put it on the same page and have both parties sign on to it.
Well, we appreciate everyone logging in on this pretty snowy day here in January. It's hard to believe or hard to imagine that we'll be, people will be getting into the field here in a few months. But hope is around the corner, and hope springs eternal in the ag economy. So you've got access via our website to last year's presentations, as well as this presentation will be made available after the fact. So if you want to share it with other folks in your bank who maybe got snowed in or couldn't make it today, by all means do so. And then you've got contact information for all of us. We've got a deep team here at the Dickinson firm working on these issues. Though we may have addressed a particular point in our presentation, we certainly all are well versed in some of these issues, and can certainly at least talk you through some problems, and then also get you connected with the person who's best able to assist you for that particular issue. So don't be afraid to give us a call, and we're happy to help you with whatever you need. So thank you, everyone. We look forward to working with you.